All right, then each side will have 15 minutes, so I emphasize side, so you have to split up your time. And you may reserve up to 5 minutes if you so choose to be appellant.
Thank you, Your Honor. May
You
it please
just let me know, too. Thank you.
May it please the court, my name is Holly Larzik-Smith. I'm here on behalf of the appellant, Mr. David Kearns. In this case, and with the panel's permission, I'd like to reserve 3 minutes for rebuttal. Thank you, Your Honor. Today we're asking the court to reverse the February 23rd, 2015 order suspending Mr. Kearns as trustee in this matter. And here the probate court violated Mr. Kearns' due process rights by failing to consider his opposition brief and failing to hold an evidentiary hearing in this matter, despite the serious allegations that were levied against Mr. Kearns and the disputed issues of fact that surround the alleged claims of misconduct. The arbitrariness of the probate court's conduct here is reflected in the procedural history of the case. And I'll begin back on October 16th, and that's when the court issued the temporary restraining order against Mr. Kearns and then set a hearing on October 29th on Mr. Lettieri's preliminary injunction claim. On October 21st, Mr. Kearns filed a motion with the probate court asking the court to convert that October 29th hearing into a pretrial conference and to also hold the briefing and rulings on the pending motions, which included the preliminary injunction, the motion to suspend, the motion for summary judgment, all filed by Mr. Lettieri. Hold all that in abeyance pending the parties' ability to explore settlement options. On October 28th, the probate court grants that motion and says that rulings are going to be held in abeyance. And this is what the court said in its order of October 28th, that the status conference is set for Friday, November 21st, 2014 at 10 a.m. The temporary restraining order remains in place. All other rulings are held in abeyance. And again, that's because the parties are considering exploring settlement options. The parties appear before the probate court on November 21st at the status conference. There's discussions about the parties participating in mediation, and again, the court issues another order on November 21st, a case management order, which says that if the mediation is not successful, then the probate court is going to proceed on the preliminary injunction claim. A few days later, the court issues another order clarifying the briefing date and the hearing date for that preliminary injunction claim. And the probate court indicates that the hearing on the preliminary injunction claim would be held on February 25th, and that briefing on the matter would be due on February 23rd. So with that backdrop, Your Honors, and with those orders in mind, 2 days before that preliminary injunction hearing, the probate court issues on February 23rd the suspension order suspending Mr. Kearns as trustee without providing him any notice, without providing the opportunity for him to be heard on that matter, without considering his opposition brief, and without holding an evidentiary hearing. And with due respect to the probate court, when we look at that order, there are errors in that order. And I'll begin on page 2. On page 2 of that order, the probate court states that Mr. Kearns has not responded substantively to either motion, and his response time has passed without a request for an enlargement of time. That is factually and procedurally incorrect. Again, Mr. Kearns had until February 24th to file an opposition brief, again going back to the preliminary injunction claim. But the probate court here never issued a scheduling order or a briefing schedule on the motion to suspend, and that's because that was being held in abeyance pursuant to the court's October 28th order. So the only thing that was going forward before the probate court was the preliminary injunction claim. Nothing else. The suspension issue was held in abeyance. And I guess to confuse things even further, when you look at page 2 of the probate court suspension order, it makes this reference, this puzzling reference to a pleading that Mr. Kearns filed on January 8th. And the probate court states mistakenly that that was Mr. Kearns' opposition brief, but it wasn't. And that's also the confusing part. First, the probate court saying Mr. Kearns didn't file an opposition brief. Now it's saying on page 2, in the same breath practically, that he did file an opposition brief. What Mr. Kearns did file on January 8th was a response to Mr. Lettieri's request for a hearing on the motion to suspend. And that's significant for 2 reasons. First and foremost, it confirms the probate court didn't hold a hearing on the motion to suspend. And secondly, it shows that Mr. Lettieri has conceded that the probate court should have held a hearing on the motion to suspend. In fact, Mr. Lettieri asked the probate court 2 times for a hearing. The first was on October 16th of 2014, and the second request was made on January 6th. And the probate court, I respectfully submit, should have held an evidentiary hearing on this matter. That's supported by the Ulinski case from this court, where at paragraph 13, this court held that due process may require a hearing prior to the removal of a fiduciary, and that should have been done here. Mr. Kearns should have been provided an opportunity to be heard before that suspension. Instead, the probate court here just assumed that the allegations being levied against Mr. Kearns were true, and without, again, an opportunity to hear from him. Had the probate court considered Mr. Kearns' opposition brief, it would have had the benefit of his defense expert report from Mr. Marvin Karp. He would have talked about the conflict of interest issues that were raised in that order, along with the claims of the serious breach of trust, as well as the payment of attorney's fees. That could have been considered by the court. Another pivotal piece of evidence that was not considered by the court that would have been provided through the opposition brief was the personal journal from Mr. Hoover's priest, who would have provided this unique insight into Mr. Hoover's state of mind, his mental capacity, and what his intentions were. A third piece of evidence that the court could have considered had Mr. Kearns had the opportunity to submit his opposition brief and have an evidentiary hearing would have been the report from Mr. Hoover's treating physician, who found him to be 100% competent. So given the serious nature, again, of the allegations being levied against Mr. Kearns, the disputed issues of fact concerning these matters, Mr. Kearns should have been given the opportunity to be heard prior to his suspension. And on the heels of that, the probate court's order also contains, as well as the errors I respectfully submit that I've just discussed, also factual determinations that were not supported by the record or under Ohio law. Here, Mr. Kearns did not commit a serious breach of trust. He had a duty to defend the trust against the allegations being made by Mr. Lettieri as a disinherited beneficiary, and he had a right to use the trust assets to defend the trust. And that's set forth in Ohio statutory law, revised code 5808.11, which says that a trustee shall take reasonable steps to enforce the claims of the trust and defend the claims against the trust. And that's exactly what Mr. Kearns was doing here. He was defending the trust against the claims being brought by Mr. Lettieri, whose goal here was to destroy Mr. Hoover's amended estate plans. The probate court also talked about a potential conflict of interest here as respects to Mr. Kearns, because he was a party to the lawsuit and that he was paying litigation fees as well, and found that to be a conflict of interest. Again, I would submit that that is not correct. Here, if a trustee is considered to have a conflict of interest every time a disinherited beneficiary names that trustee in a lawsuit, then every trustee would be considered to have a conflict of interest. Another point that the probate court made was that it took the position that essentially Mr. Kearns was somehow profiting from defending the trust against these claims. And without any evidence and without any testimony, the probate court took as being true the claim being levied by Mr. Lettieri that Mr. Kearns had been paid over $25,000 in fees since March of 2014. But again, had the probate court considered Mr. Kearns' opposition brief, it would have seen that he had prepared an accounting that was submitted to all the parties in this lawsuit back in December of 2014, and that accounting reflected that Mr. Kearns was paid a little over $4,000 in fees prior to when Mr. Hoover passed, prior to January of 2014, and then he was reimbursed a little over $1,800, $1,800 in moving expenses after Mr. Hoover passed away in January of 2014. So Mr. Kearns has not been paid any fees that he's incurred after Mr. Hoover had passed away in January of 2014. And the last issue that the court talked about, again, as I mentioned earlier, were the attorney's fees. That issue, again, could have been addressed through the defense expert report that was submitted through Mr. Kearns' opposition brief through the defense expert report that I'm referring to as Mr. Marvin Karp. So for these reasons, Your Honors, we're asking the court to reverse the February 23rd order to have the probate court provide Mr. Kearns with an opportunity to consider his opposition brief and to have an evidentiary hearing in this matter. Thank you.
Please, the court. I'm Michael Morley. I'm representing Frank and Agnes Lettieri. In the appellant's argument, I heard about the duty to defend the trust. And that line of argument ignores one very important thing about this case. There's no attack on the existence of the trust. There's no claim against the trust in the sense of someone's demanding property, demanding the trust pay for some tort or pay for some breach of contract. There's no claims of the trust in the sense that the trust has cause of action against someone. The argument in the will and trust contest case, the arguments in the general division case, which is the lawsuit that the November Trust Amendment refers to, are arguments over who the beneficiaries are. In that situation, the trustee has no duty to take sides. The trustee has to be named to that will contest and trust contest because the trustee is a party by statute. But the trustee doesn't have a duty to take sides. And there's plenty of case law in will contests that executors do not have to defend the will. They can sit back and remain neutral. The other thing that I think needs to be pointed out here is the November Trust Amendment itself creates the conflict of interest. Whatever other evidentiary disputes there are in this case, there is no dispute over what that trust amendment says, what it purports to do. It purports to say that every dime in this trust is committed to prosecuting the general division lawsuit, and that the trustee is relieved of any duty to the ultimate beneficiaries of the trust, whether they're the charities that Mr. Oldham represents or the individuals that I represent. Trustee is relieved of all liabilities. Go ahead, spend every dime, burn the village down to save it. Now, we've taken the position, as have the charities, that that is in violation of public policy. And even if it's what Mr. Hoover really wanted, and even if there's no mental deficiency and no undue influence, that is unenforceable as a matter of law. That particular argument has not been passed on by the court below. It's not right for decision at this time. But what is obvious is the conflict of interest created by that document. At the time it was prepared by Mr. Kearns, no dispute of that, witnessed by Mr. Kearns, he was an individual defendant in the same lawsuit. And he's been an individual defendant in the same lawsuit all this time. He drafts a document that says, spend my wealth fighting this lawsuit. I don't think Pope Francis could avoid having a conflict of interest there. I'm in a lawsuit. People are suing me. They're trying to take money off of me. I'm running up legal bills. I have this trust over here, which I'm trustee of, which is involved in the same litigation, is an aligned party. And so maybe as trustee, I can let the trust do all the heavy lifting. Over 25% of the trust value as of the date of death of Mr. Hoover has already been spent on legal fees. Now, that conflict exists. On the face of the document, the face of the pleadings, there's no need for an evidentiary hearing because no one argues about those facts. Mr. Kearns also made no attempt, as far as I know, to have his decisions reviewed, his litigation strategy decisions reviewed in any way. He didn't petition the court for instructions. He didn't ask for the appointment of a special trustee to oversee matters on which he had a conflict of interest. He never approached the charities and said, hey guys, here's what's going on here. Let's talk about how we're going to approach this. As an executor and as a trustee, he has a fiduciary duty to preserve assets. That might mean he has a duty to settle litigation that Mr. Hoover, for whatever reason, would have wanted to press to the bitter end. And if that's the case, again, pressing it to the bitter end benefits him individually. The conflict is obvious, and it's inescapable. And the court noticed he can't be wholly disinterested. The charities noticed. The beneficiaries that he is ostensibly standing up for said, wait a minute, you're spending all of our money. Doesn't matter. You know, the charities recognize this. And the evidence he proffered doesn't change any of that. That conflict exists no matter what Mr. Hoover's intent was. That conflict exists no matter what Mr. Hoover's mental state was. It exists no matter whether there was undue influence exerted on him or not. It exists whether or not Mr. Kearns, to date, has acted in perfect good faith or not. He still has that conflict of interest. He still has the appearance of impropriety. And it exists regardless of whether Frank Lettieri is really as bad as Mr. Kearns wants to say he is. That conflict would exist no matter who was in that position. We asked the court to remove him as trustee. Judge Stormer didn't do that. She took the least intrusive action she could possibly take. She suspended him pending the resolution of everything else. The order that she suspended him in is captioned interlocutory order. It says, I'm deciding this issue and no others. There is no Civil Rule 54B language. This is an adversary civil action. This is not an estate proceeding in rem, which by some authorities at least is a special proceeding under 2505-02. This is a lawsuit. They're causes of action that existed in 1853. The entire case wasn't decided, and there was no Rule 54B certification that the issue was immediately appealable. Well, if Judge Stormer had made that 54B finding, that would be dispositive of whether this is a final appealable order. In the absence of it, it's fatal, and that's the Whitaker-Merrill and the Olick cases. So what we have here is an order that, again, faced with an obvious, undeniable conflict of interest, the judge took the least intrusive means possible of protecting the trust, which is simply, we're going to put a neutral party who's not otherwise involved in litigation as a caretaker for the trust until all the rest of this is resolved.
What is this court to do with the language of the trial court's order that says the motion to remove Kearns as trustee is granted? I realize the paragraph ahead of that says he's suspended, but I mean, it sounds like both things are happening in one court order.
Well, I think everyone in the room here agrees that it suspends and doesn't remove. And whether we're not appealing the fact that it was a suspension instead of a removal. So if this court affirms, he's still suspended.
And what of, in that same section of the entry, where the court makes a finding that there is a conflict of interest? Would that be something that could be addressed by an appellate court later? If not
Potentially.
appealed immediately?
Eventually, yes. I mean,
How so?
well, all of these evidentiary issues are going to tie in. All the evidence that Mr. Kearns wanted to present on this motion is also going to be relevant evidence for the ultimate issues in the case. Was George Hoover under undue influence? Was George Hoover in possession of testamentary capacity? Were the actions of one party or another improper in some way? All of those issues have yet to be resolved.
I understood your argument to be, aside from those issues, the conflict exists.
Yes, on the November trust agreement, there's two trust amendments. There's July, which changed the back-end beneficiaries from the Lettieris to the charities. And then there is the November amendment, which adds this language saying fight the lawsuit. Those are, obviously, the November amendment could be invalid and the other one without that necessarily determining the other one. It's our position that that November amendment is invalid as a matter of public policy. But again, that issue hasn't been passed on yet. But the conflict of interest that it creates is, again, it's obvious. Whatever evidence Mr. Kearns wants to present wouldn't change the fact that he is operating under a document which gives him, or purports to give him, a blank check to pay for litigation expenses in a case where he has personal interest. And that's a conflict of interest.
Are you saving time for the other applicant?
Yes, I'd like to
You're at 5 minutes.
balance my time to Mr. Holden.
Thank you. And I didn't mean to rush you, I just wanted to
No.
whatever you do.
I was once told that when you run out of things to say, you should stop talking, so.
I should leave that in my personal life too, as I wrote.
Good morning, Your Honors. My name is Joe Oldham. I represent each of the charities listed as the beneficiaries in the July trust agreement that we were talking about. And I don't want to get back into the arguments that were just covered by Attorney Morley. I just wanted to indicate that we do feel the same way, that there is an inherent conflict in that November trust agreement, and the amount of money that was spent on legal fees without any contact to me or my clients, to me was just staggering. And so I wanted to just indicate that we too feel that there's an inherent conflict with that. I don't think anything that was done at the trial court level was improper. So other than that, I don't have anything unless anybody has any questions.
Apparently not, thank you.
Okay, thank you, Your Honor.
Your Honors, if I may, I'm going to work backwards. As respects to the first issue that pops out is the FAO, the final appealable order issue. Your Honors had issued an order back on November 25th, 2015, finding that a final appealable order existed for purposes of an interlocutory appeal here. And that order should remain intact here. A final
Of
appeal.
course, we didn't always say that we can revisit that.
Absolutely, Your Honor, you have that at the last sentence of the order, and I would submit to this court that this order remain intact. You have correctly determined that a final appealable order exists for an immediate appeal here under B2 of the final appealable order statute, revised code 2505.02B2. This court properly determined that the appeal should be taken immediately because a substantial right had been affected by Mr. Kearns here. He has essentially been removed. The court said suspended, but he's been removed. Someone else is in his place right now. And that determination was made in a special proceeding. This court has stated time and again in various opinions that probate court proceedings are considered to be special proceedings. As respects to the lack of 54B language that was not necessary in this case, we are dealing with not a determination of claim here. The court removed, essentially, suspended Mr. Kearns from his position of administering that estate. No 54B language was necessary. I'd also point to the Ulinski case where the court considered that a final appealable order existed for purposes of pursuing an interlocutory appeal. I believe there was a claim outstanding in that case. No 54B language was attached to the order, and the court still considered that case. The other issues I'd like to address with the remaining time that I have is the appellee's arguments dealing with the reasonableness of the attorney's fees spent. We can speculate all we want about that, but the point remains, and what I did not hear in the appellee's arguments is Mr. Kearns' ability to be heard on that issue, to submit his opposition brief. I did not hear anything as respects to that argument, that he should have been provided the opportunity and wasn't provided with that opportunity to explain his position, to explain why those fees were reasonable, to explain to the court through Marvin Karp's expert report why that was reasonable and why no conflict of interest existed in this case. Again, this is not the venue, with due respect, to litigate or discuss those issues. That should have been done through the probate court in holding an evidentiary hearing, and that is why we are asking the court to reverse the February 23rd order.
And counsel, you're out of time.
I'm sorry. Thank you very much. I appreciate it.
Thank you. This court will review the matter, take it under advisement, and issue a written opinion that will be sent to both sides, or all sides, I should say, and it will also be released on our website. Okay, thank you.